Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, why am I in this big block? Hello, everybody. Let me get out of this giant block that I'm in the middle of the screen, and I will say hello to everybody. That's a little bit better. Okay, all right. Now I feel comfortable now that I'm not in a giant block in the middle of the screen. Hello, Ruth Lang. Hello, True Crime and DIY Fails. Yeah, fails. Hello, Caroline. Hello, Jennifer. Hello, Anne. Hello, Blue River. It's interesting. Hi, Dark Side. Maestro, She Fly 9. Hello, everybody. I think we've done a roll call. Roll call, everybody here. So, interesting day today. Karen Reed had a hearing. Thanks to everybody who showed up for that. Done really on the fly. It's up in the live section. Hopefully I can edit it down. There's a lot of very interesting stuff going on in Karen Reed world. Aidan Kearney is in hot water. So to go back, Aidan Kearney denied. So it came out that Aidan Kearney, via leaked text messages by a guy named Nick Miller from Philadelphia. He goes by Joe Flipperhead on X, put out text messages between himself and Karen Reed. Karen Reed saying, "I've had it with Turtleboy." He taped my phone call and he was sharing it with Free Karen Reed supporters. And that recorded phone call ended up either Aidan Kearney sent it to Karen Reed's lawyers or the Free Karen Readers sent it to Karen Reed's lawyers, but it ended up at David Ignetti's email box in Alan Jackson's email box. Ticked off Karen Reed. Then Aidan Kearney denied. He said, "Show me the receipts." You can listen to the whole showdown on Spaces on X between Aidan Kearney and Chris the Koala John on Spaces, and Joe Flipperhead all got into it. Aidan Kearney denied. He said that they're all lying, that he never taped Karen Reed's phone calls, that no recording exists, and then all these clips of Aidan Kearney and Karen Reed. His phone recording got leaked. So that made Aidan Kearney persona non grata in Free Karen Reed, or with a lot of Free Karen Readers are still loyal to Aidan Kearney. A lot of them have turned on Aidan Kearney. So it's a house divided. They started blaming it on Meredith O'Neill, Aidan Kearney's ex. now Aidan Kearney has picked up a new charge in New Jersey for cyber harassment. It should revoke his bail, but we haven't heard any signs of that happening in Massachusetts. Even though it's in New Jersey, any new kind of charges like that would get his bail revoked. But he was in court today, and it didn't seem to, spoiler alert, it didn't seem to make any difference, or the judge was not alerted to these charges. So they're not looking to revoke his bail. So, but a very interesting, so he has desperately been trying to change the narrative, as he always is. He's been, as he did with the Karen Reed story, look elsewhere. I mean, he learned this from Karen Reed, or Karen Reed's defense was very much like this. Look somewhere else. Don't look at my own behavior. Look here. And in doing so, he said he has these emails of John DePietro trying to get Hank Brennan on his show. And John DePietro says that these emails are completely fake. We'll get into that maybe a little later if we have time. And that he went to the police with it. So that is Aidan Kearney. And Aidan Kearney says that he's dropping Karen Reed. He's putting down his sword. Strangely, I mean, doesn't any of the Free Karen readers find it odd that Karen Reed, if she was really falsely accused or falsely prosecuted for this crime, that she's not looking for the real killers? At first she knew who did it. Now she doesn't know who did it. It's not up to her to solve this crime, but has no interest, is rather be selling her story to Hollywood, and doesn't care who killed her boyfriend of 2 years. And I mean, wouldn't that be the ultimate exoneration, to get a conviction? I mean, they know. I mean, this is such an innocence fraud tactic that none of these killers ever go after finding the real killer. It's a little like OJ's 1-800 number that he set up to find the real killers. I'll never forget when Howard Stern called that number and was like, I know who did it. Give me the reward. You did it, OJ. You did it, Karen Reed. You did it, whoever. It's just like, again, a distraction technique. So creating false narratives, creating a distraction, that is the name of the game when it comes to innocence fraud, or part of the game. Let's put it that way. But today in court, it looked like Karen Reed was going to get her phone back immediately. Like immediately. So these phones were taken to investigate Karen Reed's part in Aidan Kearney's witness harassment charges. So this was a Zoom hearing on Aidan's case, of which Karen Reed's lawyers came in and said, give us back our phones. You've had them too long. And the state's position is like, look, we can't get into them. Karen Reed hasn't given us her passwords. We can't get into them. And there's a process. We need a Tate team. We need to make sure that we don't go into any kind of privileged material of her and her lawyers. And we know that Karen Reed is very worried about what's on these phones. So when the grand jury, and one of the issues that Karen Reed brought up, if you were at my live yesterday, where we went through the whole Karen Reed's lawyer, her filing on these phone issues, was like, there's nothing on here, nothing to see. Already the grand jury couldn't even indict her. But first of all, we know that there was a Free Karen reader on the grand jury, Jessica Leslie, who's already been convicted and sentenced for leaking information in Karen Reed's case, either to Karen Reed directly or to Turtleboy directly or via a friend. And the details of that have all been kept really secret. She's been really protected, and Aidan Kearney's been really protected, and Karen Reed's really been protected in that whole grand jury scandal. But we can't. So they're like, there's nothing to see on these phones. Grand jury's already failed to go forward with charges. But we know the grand jury didn't see anything that was on these two phones that they grabbed. They only saw Aidan Kearney's text messages to and from Karen Reed. But we would have to think that there's a lot more on there, or else Karen Reed would not have said in the clip of the phone calls that was released between her and Aidan Kearney, do you know what they have? Do you know what was on my phone that they took? Like, it's scary. Aidan Kearney said she's very worried about any kind of indictment for witness harassment or any kind of federal investigation, anything having to do with what's on those phones. She is nervous. So she wanted these phones back quick as possible. It looked like the judge was going to rule right away in her favor and took a quick U-turn. Very interesting hearing. Surprisingly fascinating hearing, compelling hearing today. Let's take a look at it together. Sorry, it's not visually very interesting. It's a Zoom hearing, but let's take a listen.
7 and 9, Hummel versus Aidan Kearney, 23 CR 313, 24 CR 43, 25 CR 88. If Mr. Kearney joins us via Zoom, if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Okay, Mr. Cosgrove.
Hello, Your Honor. Timothy Bradle for Mr. Kearney. Good to be with you.
Okay.
Good afternoon, Your Honor. Attorney Steve Buzang on behalf of Ms. Reed.
All right, let's deal with Mr. Buzang's matter. I'm not sure that it's necessarily, well, I guess it's denominated 24SW0.
So Steve Buzang is Karen Reed's lawyer. So you can see me up there in the Zoom meeting. There's Aidan Kearney. There's the judge. Just a reminder about this judge.
Is that a journalist?
So this is the same judge that they went up in front of before on the bail review hearing.
Filing a witness intimidation case. So that's what I want to invite the court to look at.
So your view is that a journalist can bring a dozen other cars, honking horns in front of the neighbor, in front of a witness's house, and calling out to the neighbors to call on their neighbor to do the right thing.
Well, it's not something that plays well in polite society. I wouldn't do it. You wouldn't do it.
Is that's what you say is journalism? That's covered by the journalistic privilege. That is to say, it's covered by the First Amendment.
Covered by the First Amendment, Your Honor. Absolutely. In Article 16.
Even if the other dozen cars or however many cars go out are not.
I'm sorry, are not journalists.
So what they're talking about is the rolling rally where Aidan Kearney led a group of people from witness to witness's house in this and screamed killer, murderer on their lawn, held signs. They're saying his lawyer here is saying that it's all protected under the First Amendment and that this judge isn't buying it.
It involves another issue that's a difficult issue, but should really come out on Mr. Kearney's side, where how much control does he have over his people that follow him and want to cheer him on? You know,
how much control does he have? He's the one who said, meet me at the parking lot of the supermarket and we're all going to go from witness to witness house. And it's believed that Karen Reed provided these addresses of the witnesses in this case.
Who can control a mob?
According to the papers, there was a meeting place.
Yeah.
And no one knew where they were going in advance.
But these
and then this defendant, I'm reading between the lines now. I don't think the papers are explicit, but they suggest that this defendant then directed them to the various locations that they were going to drive by.
Sure, that's completely.
So that's completely covered under the First Amendment, guys. Completely covered. Anyway, so there's a little clip of Judge Peter Krupp. So that's who they were up in front of today, same judge. And he looks like he's going to rule in Karen Reed's favor, like you got to return the phones. Case law covers it. Take a listen to how quickly it turns.
004. But it really is a request for setting a set of conditions for searching through Ms. Reed's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reed's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within the days of the authorization. Let me just see if I can find it in the papers.
So here's the judge going, let me find the date. This seems like you've had these phones for a long, long time. Hand them, I mean, it looks like he's going to go hand them back. I go, oh no. Like, hand them back. And you'll see once Cosgrove starts talking, you realize that case law is not on their side. Hey, spoiler alert. Am I spoiling this too much? Am I spoiling all the... Yeah, if you want to listen, Rosewater, if you want to listen to Natalie's interview, it's up in full. I notice Aidan Turtleboy Kearney is talking about Natalie again. So Natalie Bernschneider-Wawicki was the middle woman between Aidan Kearney and Karen Reed in the beginning, before they started talking directly every day. But so if Karen Reed if she didn't organize the rolling rally, but she gave let's talk about complicity for a second. She gave the addresses of the witnesses to Aidan Kearney, knowing what he was going to do. She's complicit. So if you say, I'm going to rob a bank, and I mean, if I get you the, I don't know, the gun or a ski mask or anything to help you do it, I'm an accessory. Same thing here.
You may have, well, okay. I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the...
So he's like, also the judge thought that all the material was downloaded from these phones. And Robert Cosgrove for the state was like, look, we can't get into them. Karen Reed won't give us her password. We can't even start this process, hence the delay. And then the judge said, well, then this brings up all the issues from the defense. That if you've had these phones forever, You can't keep them indefinitely according to what the defense is citing in their filing. But it turns out that their case law does not support their position. Spoiler alert, take a listen.
Various things that Mr. Buzang presented in his opposition, which is the Commonwealth having been in possession of the phone for an extended period of time has a finite amount of time in which it can seek authorization to search or to do the search. Let me just see for a second. Yeah, so in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph, the search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No,
they haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the, attempting to break the logon information or the receipt of the passcodes.
Okay, well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is the practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol. As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no question that more than a year has passed and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right. The case law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276.
Okay, so does everyone get what's going on? So the case law that Karen Reed's lawyer, Stephen Buzang, cited in his motion to get these cell phones back said that you got to give it back because they have no right to it. But that case law, Segura versus the United States, has to do with warrantless searches. Because they did have a warrant, the state has the right to hold these phones until the case is over. And that's Aidan Kearney's case. So, to be realistic, we don't know if there's stuff on Karen Reed's phone that's going to be used to bury Aidan Kearney and not Karen Reed. To get any kind of jury in this area to convict Karen Reed of anything is going to be near impossibility. She's really, and Aidan Kearney too. They're really above the law at this point. They're such folk heroes, and that's one of the things that innocence fraud campaigns do so well. Is they make the cops into criminals, and they turn the criminals into folk heroes. So he's saying, no, we have the right to hold these phones to the end of Aidan's case. That's how it turned like on a dime in this hearing. It was like such a switch. In the beginning, you thought you were like, Karen Reed's going to get her phones back immediately. They've had them too long. Give them back. Don't search. I thought, oh, Karen Reed's going to walk away again. It's like everyone else in this case has had, and even not in this case, it was just a witness in this case, has had their privacy and their text messages and their personal things put on blast to deflect away from Karen Reed own criminal behavior, but not Karen Reed. She doesn't have to testify. She doesn't have to give up the passwords. When they went to get these phones, she was taking the phones, to Florida. They just watched her phone being tracked to Florida. She did everything to keep her phones away from the state.
Sections 3 through 8. Now, I've looked at the cases that Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, Judge.
So Kitty's, thank you, Kitty's, says, Roberta, your logo was looming nice and large. Thanks so much. Just a couple over. Is that for everyone? Like, so whoever comes in to the Zoom hearing, do they get, like, if I go to a different channel, is that channel going to be like 2 down from Turtleboy, or am I on every channel? Like, that's what I'd like to know. Let me know if you watch this on a different channel. I don't know how Zoom works that way.
And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that results that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the boots trudge through mud or blood or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment in Article 14 of the Search and Seizure Law requires law enforcement to act diligently to obtain a search warrant without unreasonable delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's an independent, any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here, they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case. But I think it is relevant in terms of now they want to come back and look at her 2 phones, and they have all that evidence from Mr. Kearney. They have, I think,
all right, no, I understand those arguments, but I'm still trying to find a case, if you have one, that comes up in the context of a warrant authorizing the initial seizure of the device, and then
he's like, you gotta have case law. Says there's like, well, look, this happened 2 years ago. They already have everything they need. I mean, they really doth protest too much. As I said yesterday, like, there's nothing criminal on here. They have all the messages from Karen to Aidan on his phones and back. But I think I think just this is the second time she's asked, to get these phones back. So she asked first time round with her murder vehicle, and the murder vehicle was returned, but not the phones. So she wants these phones back desperately, without them being searched, without giving up the password to them, because I think my opinion is that there's something pretty damning on here. So
there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
So now they're looking for case law. Can we bring find some case law?
I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the Fourth Amendment, I think again, this I don't think would have came up if we just let it stay and didn't ask for the two phones. It was only after I asked for the two phones that now this is somehow an ongoing investigation. When they've had the investigation was done, and there was nothing to it. If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But okay. I think in terms of reasonableness and timeliness, Judge, I think, it's almost 2 years.
Okay, I'll take it under advisement.
I'll take it under advisement. Meaning, I think that's a big NO. It's a big NO. It's a big NO. It just switched. I've never, sometimes, you go to these hearings and you think, like, just because a judge will press a lawyer and get them to argue their side as vigorously as possible, they'll ask some really tough questions. So you don't know exactly which way. But this way, the judge came in like, okay, let's get those phones back. Like, you don't really have from what I've read, apparently it was a good filing, convinced the judge before Cosgrove was like, no, that has to do with, you'd think the judge would be familiar with that, but no. It figured it was like, no, that's warrantless searches. We had a warrant in this case, so yet. So, spoiler alert. I mean, do you want to go on with this? I mean, there's maybe 5 more minutes. So it goes on. They have to go through her phones with a taint team. It's not a long hearing. So if we can speak
and the
through
matter,
it.
it does have a next date of December 5th.
You know what? I'm sorry, Margaret. I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
I do, Judge. I don't think the Commonwealth, in the preventive medicine case, the defense has some say in, who would be a part of the taint team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you for the.
Can we put Melanie Little, the glarer, on the Tate team? Can we just fill the Tate team with free Karen readers? Can we put Barry Scheck from the Innocence Project on the Tate team? We want some input now on who's actually going through the phone. Or can we find someone who's totally incompetent to be on the Tate team? They won't find anything. Do you remember when they downloaded Karen Reed, the data from Karen Reed's car the first time? And it was the defense expert doing it. And they somehow missed a whole bunch of data first time around. We had to wait for that for the second trial. Can we find someone like that?
With regard to the protocol that's proposed by the Commonwealth. That was part of the frustration that I had with the papers as they came to me.
Crossing over, I understand, Your Honor.
Yeah, so there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the two phones. I take it you can make a backup of the phones, and do the search off the backup, and you can promptly return the phones to.
Listen, Your Honor, we suggest that the prosecution that the state use these phone experts. They're also on YouTube. They have a show, the JFK show. We think that they would be awesome experts to go through the phone. Actually, you know what? Aidan Kearney himself is an expert. I'll have him go through Karen Reed's phone. Oh, yeah.
Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But before we get to that, Judge, could I just have a couple of weeks to provide some opposition to that? It'll be
opposition to what?
To the taint team part of the government's motion.
No. You can talk to Mr. Cosgrove. The two of you folks can talk and come together, come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay? Not it's elaborate.
Okay, this is a innocence fraud line here from WKRP. Not in Cincinnati, but Podcasting Network says, people must realize that this is bigger than Karen Reed. If we allow this, then they can do it to you also. Okay, so this is like a innocence fraud narrative. Like you might never do a crime, but that doesn't mean you won't be falsely accused of doing a crime. Chances are, you're much more likely to be a victim of a crime or be a family member of a victim of a crime than being ever falsely accused. And I'm not saying Karen Reed wasn't falsely accused, and she was treated pretty well, and she got rich off of grifting off of her crime. There's nothing wrong with them keeping her phones. They had a warrant for it. If you're involved with witness harassment, they might seize your phone. This is zero that I'm worried about when it comes to the way that this is done. What should I be worried about, WKRP? I'm not involved in harassing witnesses in my murder trial, which I was rightfully accused. And there is no 50-plus person conspiracy conspiring against Karen Reed. Why did they want to conspire against Karen Reed? No one knew of Karen Reed until she clipped John O'Keefe and reversed him into him with her foot 75% on the gas pedal, going up to speeds of 24 miles an hour in reverse. And then confessed to it multiple times to first responders that I hit him. Next morning, never called 911. No. I think you're much more likely to be treated like the O'Keefe family than Karen Reed. That's the kind of treatment that we should worry about. Murderers grifting off of their crime. People getting rich off of spinning a fantasy narrative that villainizes the police and the state in favor of getting a killer off, which was successful.
For a briefing, but if I'm going to allow this, there's going to be a taint team protocol put in place. And I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before, okay? It's not all that complicated. So I'll give you 10 days to do that. If that gives you folks enough time to confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Is that enough time?
No, that's fine, Your Honor.
Okay.
Happy to talk to Mr. Booth.
All right.
Okay, so they have 10 days to get a taint team together and agree on they have 10 days to get the parameters of the taint team together between the defense and the state and agree on. And if they can't agree on certain things, they'll put them before the judge. But right as they're about to, so we think we're like, okay, we're about to, wrap it up with this hearing. That's decided. Karen Reed, you're not getting your phones back. Let's look at the poll going on. I put up a poll. So it's kind of an interesting, I like to see this because it lets me know who's watching. Gotten actually a lot of Karen Reed supporters checking in lately. So we have about 24%, so 25% of my audience right now says Karen Reed should get her phone back immediately. So those, I would say those are Karen Reed supporters, and about 76% said no. So, I mean, you can kind of, I would think that this would, or 77%, now it's a little. So I think this would go along the lines of who supports Karen Reed and who doesn't. I mean, there's no, why shouldn't she not get it? Karen Reed can buy as many phones as she wants. And I mean, if you're saying that we should worry that they're going to rummage all through her personal items on her phone, don't commit a crime if you want to keep your privacy. I mean, it's much more concerning that people who did nothing but their job or just happened to be brought in by Karen Reed to mix it all up that morning. Otherwise, there's no need for her to call Jen McCabe. I have some free Karen or Carrie Roberts, but she needed other personalities to deflect attention away from her and to make the 911 call. And Karen Reed recorded their 911 call to all make it look like there was someone other than Karen Reed responsible for this crime. Otherwise, if she had just done the right thing and gotten help for John O'Keefe instead of help for herself. And Karen Reed supporters have said, oh no, she had to call Jen McCabe that morning. She knew where John O'Keefe was, okay? Everybody, she led them to his body and to her handiwork. And said, oh, this is Karen Reed supporters. She didn't know where he was. They were the last people with, no. The last text message she got was from Brian Higgins that night. And the first person she called was Michael Camerano, who left the bar early because his son lost his tooth playing hockey. But why is she calling Michael Camerano first, Catherine Camerano? Make that make sense. Why didn't she call Brian Higgins? So her first choices were the Cameranos. My feeling is because they're wimps. They're self-protective wimps. I mean, we saw the way that they testified. Catherine Camerano, I'm sure, remembers everything that, or the majority, let's put it this way. It's burned in her brain what Karen Reed told her that morning. And when asked, she said, oh, she was just a lot of crazy yelling, just nonsense. She knows Karen Reed made a self-incriminating admissions to everyone else that morning, except Catherine Camerano. We're supposed to believe that. And Michael Camerano, what a great friend he was to John O'Keefe. They hung out every Friday night together. But after he's murdered, it takes until the second trial to bring up the fact that John O'Keefe was angry at Karen Reed that night because Karen Reed couldn't come out to the bar because she had to meet her plumber, Richie, to fix her hot water issue. And apparently Richie showed her a part of her hot water issue that was, I assume it was a pipe, part that was all rusted. And he puts the toilet seats on crooked, and he was going to Home Depot, and he would be back the next day. We've never seen if Karen Reed actually made those text messages to Richie the plumber. We don't even know if Richie the plumber exists. I put out an SOS. I'll put it out again. If anyone knows Richie the Mansfield plumber, get in touch with me. RobertaGlass23@gmail.com. But it took Michael Camerano to the second trial to bring all that up. And he did like in the most mouse-like style. He barely, he was so things were going great with Karen Reed and John O'Keefe. He was a little upset because he would have fixed Karen Reed's hot water issues himself. There was no need for her to delay coming out that night and calling a plumber. This is the last thing they argued about that night. We know this is the thing that made him angry, and it's the part of the story that has been totally ghosted. Karen Reed's fabricated narrative around this plumber. No one wants to talk about the plumber. Aidan Kearney didn't want to talk about the plumber. Does everyone get why it's important to the story? It's the last thing they were talking about via text that night. And it's the thing that Karen Reed, in all her interviews, in all her documentary, all her time in front of a camera, she never talks about is her hot water plumbing issues. She's totally ghosted from the story. Why? I think the reason why is because she made it up. I may be wrong. Show me the text messages back from Richie. Bring Richie in. Why wasn't he a witness for the defense? And if she did make it up, it certainly paints a picture that's consistent with the picture that was painted from the other text messages of Karen Reed, that Karen Reed would lie to have power and control over John O'Keefe, to make him angry, to keep him involved. We're talking about, this isn't the first DV relationship that ended with one person taking the other person's life, i.e. Karen Reed taking John O'Keefe's life in a brutal, horrendous, horrific way. So this is a person that you've been with for 2 years that you trust the most, that, when your back's turned to them, clips you with their SUV. They have to take microscopic pieces of your taillight out of your shirt after you're dead. There was no time. The timeline does not support any planning. There was no opportunity to plan any evidence and no motive. But that doesn't stop them from going on and on and on about it. So the way that this ended, let me just get to the end of this. Hey, Wesley, hold on 1 second. I'll get to you in a hot minute. Hold on. So right at the end, Aidan Kearney's lawyer is trying to get Robert Cosgrove off of the prosecutor, off of the case. And he's like, can I just intervene at the end here and argue that Robert Cosgrove should be thrown off of Aidan Kearney's case?
All right, I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be, what are we? We're already October 8th. How about if you get it to me by the 21st, October 21st?
Enough, Judge, thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So both sides really need to be reasonable.
Understood.
Okay, 10:21.
Okay. We'll wait your responses. You have until October 21st. And the matters next on
Thank you, Your
December
Honor.
5th.
Thank you, Madam Clerk.
Yeah, 2 p.m. for hearing on motions to dismiss. Thank you. We'll see you then.
Your Honor, may I be heard on the disqualification issue?
Yeah, so he wants to disqualify Robert Cosgrove as a prosecutor in this case.
Mr. Bradel, in what docket did you file a motion for disqualification?
So that's Bradel, who's Aidan Kearney's lawyer, pipes up at the very end
Judge,
here.
I believe that was filed in all 3 dockets. This one is styled as a in re search warrant docket. It's 20. I have it right here. Just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10/6. I'm not going to hear you on that until I get a response.
Sure, I understand, Your Honor. It's just a little bit cart before the horse, I think, because counsel is forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing. until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not. I will not. I'll put you on for a hearing on a motion for disqualification.
So there's Bradle saying, like, you can't go forward with anything to do with these phones. Again, delay. Just hoping they get these phones back. It must be bad for Aidan Kearney and Karen Reed until you throw Robert Cosgrove off of it. And maybe we can get another prosecutor that's not quite as sharp. He doesn't see the significance and how these two worked with each other criminally to harass witnesses. Let's get someone who's really... Is Judge Canoni, can she work as a prosecutor in this case? Can we get her on as a special prosecutor? Wesley loves Octoberfest. More cat door money. Thank you very much, Wesley. Nice to see you. Thanks for supporting the channel. Next time I'll try to make this Zoom hearing more visually interesting. I'll try to blow up at least Aidan Kearney and the judge so we don't have to look at this big phone thing. I'm just happy I got it. I got into the Zoom hearing, got it recorded. That's what I'm happy about.
But I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure. I understand.
When would you like to schedule a hearing on that motion? Margaret, do you have? We could do December 5th, but let me, do you have the motion for disqualification? I have an affidavit.
Sorry, Judge, there's an impounded and a redacted one. Redacted for the public docket, and there should be an unimpounded one, or unredacted one rather, that's for the court. And I believe they were filed in all three of those dockets. The 24 and the 23 case for Mr. Kearney and this in-ray search warrant case. And if not, I'll just make sure Madam Clerk has them in this case, but.
I think they might be downstairs. I didn't think it was in your
sure.
Today, and the files are so voluminous.
Okay. What's the status of the 2025 case?
The
25 CR 88.
That's had a little bit of a back burner, Judge. I think there's a pretrial.
So spoiler alert, they get a December 5th hearing on throwing out at 2 p.m. Throwing out Robert Cosgrove. That's the end of the hearing, but pretty fast. I thought it was a pretty interesting hearing. Surprising for Massachusetts. In this case, what else do we have? I went over the DePietro stuff. So that's going on. I mean, it's just been just the way they operate, you know. He says he's going to, I mean, I guess I'll go over the emails that Turtle has listed John DePietro, but the thing is, John DePietro never owned that domain name. A quick Who's It search and Wayback Machine search shows a man in Italy has owned that domain as early as 2001. There are a few times the registration has lapsed only for that Italy guy to reclaim ownership. It's bounced around the last couple of years and was even listed for sale in 2024. It was registered again in June 2025, that same month. Turtle purchased the site, JohnDePietroShow.com, and redirected it to his own donation site. If you look up DePietro's actual website info, it shows DePietro's name, address, and phone number under the registration. The fake John DePietro and John DePietro Show are both registered privately with no contact info for the owner. Turtle couldn't take a few minutes to look this up. Took me maybe 20 minutes to find this online. So let me see if I can find the actual, I think I have the actual letter or email. I mean, it sounds like, it really sounds, if you listen to it, I didn't find it believable. To me, it sounded like a Turtle writer, just the language of it. Hold on one second. Okay, here we go. So let me just show you what he claims, John DePietro. I mean, it's just all this sort of. So this is the email that Aidan Kearney says that John DePietro wrote to Hank Brennan's agent. I mean, I don't know why Hank Brennan would have an agent. I mean, he hasn't put himself out in the media at all. Are you saying that Hank Brennan's agent is only dealing with John DePietro? I mean, it doesn't really even make any sense. Dear Mr. Brennan, I am reaching out again to respectfully request that you consider taking over the prosecution of Aidan Kearney. Source, I mean, I've never even heard of the idea of Hank Brennan taking over the prosecution of Aidan Kearney. Sources have told me and others that most, if not all, of the charges against Mr. Kearney may soon be dismissed. I haven't heard that. The development is deeply concerning to the McCabe and O'Keefe families who feel very overlooked. So the McCabes come first over the O'Keefe family. I mean, this is their obsession. The McAlberts, and then the O'Keefe family. So this is they've been their target, the McCabes, then the Alberts, and then the O'Keefes come last. The Alberts get ghosted in this, strangely. The McCabes and the O'Keefe family who feel very overlooked by District Attorney Michael Morrissey's office. There's another one of their obsessions, Michael Morrissey. Mr. Kearney's actions, including the alleged illegal recording of Karen Reed, which has now come to light, have caused significant distress despite outreach from some of Ms. Reed's adversaries encouraging her to press charges. She has chosen not to pursue this course. So they're talking about the wiretap of Karen Reed. If Mr. Kearney avoids accountability, many, including myself, will lose faith in the Commonwealth justice system. It sounds like Aidan wrote this. We believe your leadership in this case could ensure that the charges and pursued effectively, preventing their dismissal. Mr. Kearney's actions have caused considerable harm, and we feel strongly that he should face appropriate consequences, which we believe would be life imprisonment. Life imprisonment. I've never heard anyone on this side say Aidan should do life imprisonment for witness harassment, but okay. Thank you for considering this request. We tried doing life imprisonment for witness harassment in Massachusetts. Thank you for considering this request. I am confident that with your expertise, justice can be served. Yeah, to me, it sounded like Aidan Kearney, just nonsense. Get a new enemy, rile up the base behind him, and put someone who's, John DePietro, interviewed a whole fake juror. They catfished him with a fake juror. He's always been an enemy of, Free Karen Reed, put him up like his red meat for the Free Karen Readers and away from himself. So that's how they spin the narrative. It's nonsense. Yeah, just some nonsense. And the way that he reads it is so interesting. He did a live on it that I listened to last night. He talked a lot about, I put up an old, the interview is not new. I played it before on my channel of Natalie Bernsteiner Wiki, but I don't think a lot of the Free Karen readers had heard it. I was shocked. I just put it up as a favor to one of my listeners who said, we were going over it this recently because of the grand juror issues, etc. Someone said, could you put it up? So I just put it up as a, just for people who just wanted to listen to and it's done well for my little channel. So I was surprised to hear Aidan Kearney talk about Natalie Bernschneider-Wawicki, who I guess he had, for the most part, had made her an enemy, calling her Natalie the German, but had mostly ghosted her out of the narrative of his involvement in Karen Reed's defense and as Karen Reed's propagandist, innocence fraudster. So I thought it was curious that he was talking about her last night, just out of the blue. But, he goes through the email and he's kind of saying, is this fake? The way he does, he sort of plays with it. Like, is this fake? My sources didn't say it was fake. I didn't check out my sources. Yeah. He's a highly manipulative, dangerous psychopath, Aidan Kearney. Yeah, it was really concerning to watch him go through it and just kind of be like, well, is this fake? You're saying it's fake? DePietro says it's fake, but why are you lying? The same thing, same kind of stuff he did around the taped. Show the receipts. Why are you lying? He knew he recorded Karen Reed. He knew he played the tape for at least his ex-girlfriend, Meredith O'Neill. And Meredith O'Neill has made a statement. We'll go through all the free Karen Reed drama today, or some of it. She's made a statement, and this is what I find interesting or compelling about Meredith O'Neill's statement. So here's her statement. Thank you. I don't want an apology. I just want the attacks to stop. Well, Jennifer McCabe would have liked the attacks to stop. The O'Keefe family, who had been through one trauma after the other, were all vulnerable, would have liked the attacks to stop. So it's so easy when it's not you, right? On everyone. It's a one-sided feud. And for those asking why I didn't address this before, I don't respond to any of her posts about me. As tempting as it is to want to defend myself, it just makes her go harder at me and others I care about. I don't want to clear up the lies because I'd be at it all day. I didn't respond when my family was posted. So she was being accused of taping Karen Reed and Aidan Kearney on her watch. I didn't respond when my family was posted incessantly last week, and I didn't want to get out of bed because it was so hurtful. Family members who have nothing to do with any of this, by the way. I don't interact with her at all. I've never gone after her, never shared her texts from our year-long friendship, never wished her ill will. Someone else asked me directly yesterday, so I figured it was a good opportunity to respond. And maybe she'll stop bringing it up. I doubt the other two people being mentioned daily want that to continue either. Okay, so it's so easy. It's so easy when it's not you to, right? So I think I'm going to leave it there for today. I think I've gone through everything that I want to talk about. So, this is, it's an eye-opener into how these innocence fraud narratives work. And I don't believe Aidan Kearney when he says he's dropping the sword and he won't talk about Karen Reed anymore. It's too profitable to him. His whole audience is there to listen to him talk about Karen Reed. I don't believe him. He may pause on it for a minute. I doubt that even, but this is where where he makes his money, off of creating fabricated narratives around this case. And he's convinced a good portion of the country, if not the world, that his fantasy narratives are true in this case. So that is what I have to say for today. please hit the thumbs up. Support this channel. Links are always in the description of this episode. You can send a donation via Venmo, buy me a coffee, or become a Patreon member. Working on a Patreon show, at least one or two of them, come out very shortly. Thank you all for watching and with me. And I will be back hopefully tomorrow at 6 to talk about true crime cases some more. And so maybe even another innocence fraud case or this one some more tomorrow at 6 p.m. Don't miss it. Eastern. See ya. Thanks for listening. See you tomorrow.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, gin, gin, like John, you were my mark. My innocence fraud campaign is my biggest hit. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim.